Swayam Prabha. Digital India. Educated India.
Welcome to the course on medical law. This lecture will be about patenting therapeutic practices and techniques. The concepts covered in this lecture are patentability of diagnostic methods, patentability of therapeutic techniques, non-patentable subject matters, Section 3I of the Patent Act 1970, comparative perspective in foreign jurisdictions. The keywords of this lecture are diagnostic methods, therapeutic techniques, TRIPS, patent eligibility, non-patentable subject matters. Diagnostic methods are essential for medical practitioners to acquire information necessary for prevention, detection, treatment and monitoring of diseases and conditions. The progress of medicine and healthcare can be linked to enhancements in the efficacy of diagnostic methods. Article 27 Clause 3 Clause A of the TRIPS agreement, which is part of WTO, grants the member countries the freedom to determine whether patents can be awarded for diagnostic, therapeutic, surgical methods for the treatments of humans or animals. The issue of patentability of techniques of treatment is a highly debated topic on the global scale. So, under the TRIPS agreement, specifically Article 27, it is the freedom of the countries or freedom of the parties to determine whether patents should be awarded for diagnostic techniques, therapeutic techniques or surgical methods which are for the treatment of ailments affecting human beings and animals. So, this is clearly a flexibility provided under the TRIPS agreement. Let us see what is India's stand with regard to this specific TRIPS flexibility. India has chosen to classify certain processes and related subject matter as non-patentable innovation, taking advantage of the freedom offered under the TRIPS agreement. So, in India, Section 3I of the Patent Act as modified specifically prohibits certain subject matters from being eligible for patent. So, as we have discussed in one of the previous lectures, in order to be eligible for a patent, the invention must be novel, it must satisfy the criteria of inventive step, it must also satisfy the criteria of industrial application. In India, Section 3 of the Patent Act gives some cases where an invention will not qualify as a subject matter for patent. Section 3 specifically deals with what are not inventions. So, Section 3 in effect prohibits certain subject matters from being eligible for patent. Let us see what is the rationale behind Section 3. To address this question, we need to examine the different public policy factors and assess the societal consequences of issuing patents. Proponents of giving patents to medical treatments claim that inventors and pharmaceutical companies require incentives and rewards for revealing their ideas to society, which is in effect encouraging the transmission of knowledge. So, pharmaceutical businesses argue that whatever incentives are available is not adequate, and they argue for grant of patent monopoly in order to ensure that they will be able to recoup the investment they made for the research and development of new pharmaceutical innovations. So, proponents of this philosophy argue that extended patent terms or complete grant of patent monopoly is essential to meet the requirements of global public health. Nevertheless, an inventor is entitled to royalty or license fee each time a physician carries on his technique. Such a scenario will only serve by discouraging physicians from choosing the course of action or downplaying it in front of the patients, as it requires a lot of expenditure. This will defeat the goal of the invention, which actually is lessening human suffering, particularly in the context of medicine. So, think of a scenario where therapeutic techniques are patented. What will be the effect? Every time the technique is used by a physician, royalty will have to be paid to the patentee. So, this will increase the cost or pharmaceutical care and significantly affect the public health. Patents should not be awarded for another reason. If the patent holder files an infringement claim, the patentee's privacy will be flagrantly violated. Awarding of these patents will simply drive up the already exorbitant cost of healthcare, and worldwide objective should be to lower the healthcare cost and promote access to it for all socio-economic groups. Now, let us see Section 3I of the Patent Act. Section 3I states that any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic or other treatment of human beings, or any process for a similar treatment of animals to render them free of a disease or to increase their economic value or that of their products are not inventions within the meaning of the Act. So, as I explained earlier, Section 3 prescribes what are not inventions. So, if it is not an invention within the meaning of the Act, it does not qualify for a patent. So, these are specific exclusions given under Section 3 which will render them non-patentable subject matters under India's patent law. Now, let us see the interpretation of Section 3I. The term diagnostic as used in Section 3I should be interpreted in conjunction with other terms in the section and understood within the framework of the intended definition. The use of the term diagnostic alongside words such as medicinal and surgical clearly refer to modes of treatment, implies that diagnostic should be understood as the process of finding diseases or abnormalities in order to treat subjects. Interesting part is Section 3 specifically uses the word diagnostic. So, what is the meaning of the word diagnostic? Is it identifying the disease? Is it just a screening technique, or is it a method of treatment? Because this determines, or the meaning you denote will determine the effect of Section 3. What is excluded from patentability is diagnostic techniques. So, as we see here, diagnostic should be understood as the process of finding diseases or abnormalities in order to treat the subjects. So, what is not patentable? Inventions pertaining to surgical processes are not patentable. So, those are which involves combining of tissues or surgical isolation of bone marrow, tissue or skin from the body. So, these are all surgical processes. Surgical processes are unpatentable subject matter. So, if it is patentable, then the problem is there will be monopoly rights over the surgical process, which will detrimentally affect access to affordable health care. Thus, surgical process is an excluded subject matter under section 3. So, processes such as combining of tissues, surgical isolation of bone marrow, tissue or skin from the body, even if an innovative method of doing this surgical process is identified or invented, but still it will not be a patentable subject matter under the Indian Patent Act. Similarly, inventions involving therapeutic methods such as those related to the use of drug and dosage or combination vaccination, these are all non-patentable subject matters. Similarly, inventions pertaining to diagnostic procedures, for example, identifying liver fibrosis in a human subject by acquiring blood sample from a suspected individual. So, these are all diagnostic procedures which are not patentable under section 3. Now, let us see what is the difference between method of diagnosis and detection. According to the Manual of Patent Office Practice and Procedure, diagnosis refers to the process of determining nature of medical ailment by examining its history, symptoms and conducting tests. So, diagnosis has a methodology. When a medical practitioner undertakes diagnosis, he follows through a procedure. The determination of individuals' overall physical condition, such as a thorough fitness test, is regarded to be diagnostic. So, as per the Manual of Patent Office Practice and Procedure, diagnosis means that it is a process of determining the nature of a medical ailment. So, how will you examine the nature of a medical ailment? For which the history of the patient needs to be examined, the symptoms has to be identified and some test has to be conducted. So, all this becomes part of the diagnosis procedure. Diagnostic techniques are designed to determine if a disease is present or not and are crucial for making therapy choices in individuals who exhibit symptoms. So, these are actually designed to identify the disease in order to see whether the disease is present or not. If the disease is present, then the diagnostic techniques will help the doctor in identifying or making therapy choices. Section 3I of the Act does not include detection tests. Detection tests aim to identify early signs or risk factors of a disease that may never actually develop, and they only serve as markers of susceptibility in healthy individuals. So, if you take an example of a detection test, it is aimed at identifying early signs or risk factors associated with a disease which may not have even developed. So, this only serves as a marker of susceptibility in healthy individuals, which is not covered in section 3I. Detection tests are used for predicting the progression of the disease rather than diagnosing it in individuals who are already affected. It is important to distinguish between detection tests such as those used for screening, prognosis methods that assess the course of disease, as they are fundamentally distinct from diagnostic procedures used for treatment. So, diagnostic procedure actually leads to the identification of a disease and helps the doctor or the medical practitioner in making an informed choice as the type of therapy that needs to be used to cure the disease. So, that is the purpose of diagnostic procedure. So, what is excluded under section 3 is diagnostic procedure and not normal detection tests. Now, let us see one case, Chinese University of Hong Kong versus Assistant Controller of Patents and Designs, which is a very recent case, 2023 decision from the Madras High Court. The Chinese University of Hong Kong Knowledge Transfer Office and another company are the appellants in this case. They had filed a patent application for a non-invasive prenatal screening test to determine fetal genomic information from a maternal biological sample. So, what they have done is they have developed a test which is of a non-invasive nature. It's a prenatal screening test. The purpose of this screening test is to determine the fetal genomic information from the maternal biological sample. So, sample will be taken from the mother in order to identify the genomic information of the fetus. So, they applied for the patent, but after examination the patent application was rejected by the Assistant Controller of Patents. On the ground that Section 3I of the Patent Act provides exclusion for diagnostic procedure. So, under Section 3I, diagnostic procedure is not eligible for a patent. So, on this ground, the patent application was rejected by the controller. So, now the case was taken before the High Court. So, now let us see what are the arguments for the appellants. So, appellants is the university as well as the company who has developed the screening test. The appellants contended that since their test method does not identify a patient's illness, it is not a diagnostic technique. They argued that interpretation of Section 3I should limit to the term diagnostic to in vivo diagnosis and exclude procedures used in vitro. So, their argument is fundamentally this, that whatever we have developed is not a diagnostic technique, it is only a detection test, because it does not identify a patient's illness. And they also makes this argument that the exclusion provided for diagnostic techniques under Section 3I should be limited to those which are in vivo diagnosis, and procedures such as in vitro should be excluded. The Manual of Patent Office Procedure 2010 makes a distinction between in vivo and in vitro diagnosis, as which was cited by the appellants. The Assistant Controller argued that method's diagnostic nature was asserted throughout the whole specification. So, on behalf of the respondent, it was argued that the method which is claimed in the patent specification asserts the nature of a diagnostic kit, which is prima facie ineligible for patent protection under the India's Patent Act. They contended that the word diagnostic is not restricted to in vivo diagnosis as given in Section 3I, and that the phrase process suggests that all steps in the diagnostic procedure should be considered as a diagnostic procedure. So, the argument was raised that the claimed kit, which is explained in detail in the patent specification, is actually a diagnostic test. So, now let us see in vitro and in vivo diagnosis. The tests known as in vitro diagnosis are used to identify illness, ailments and infections. So, in vitro diagnosis are used to identify illness, ailments and infections. The term in vitro means that in glass, denoting that these tests are usually carried out in test tubes or a related apparatus, whereas in vivo testing is carried out within the body. So, healthcare facilities, labs and even homes can take in vitro tests. Actual tests can be run on a range of devices from simple handheld test to intricate laboratory apparatus. Now, let us see the decision of Madras High Court. The High Court decided that an invention would not be eligible for patent protection if the claims revealed a method of diagnosing the patients in order to treat them. It was further held that an illness need not be conclusively identified by the diagnostic testing. That is the decision of the High Court. It was decided with reference to screening test, these tests must be considered as diagnostic techniques if they are able to detect the presence of the disease as well as pertinent feature and information. Section 3I cannot be avoided by test, by simply designating it as a screening test. So, if the technique is intended to identify the presence of a disease, then it has to be considered as a diagnostic technique. The ability of the test to identify the patient's illness or ailment or condition for treatment per se serves as the yardstick for determining whether the invention discloses a diagnostic procedure. So, we have already seen that if the claimed invention is a diagnostic procedure, then it is excluded from patentability. Regardless of the name of the patent application, it would not be subject to section 3I of the Act if the person skilled in the art is not able to diagnose the disease using the process or method described in the invention. But if a medical practitioner cannot use a particular test to identify the presence of a disease, then it does not qualify as a diagnostic test. The court emphasized that while fetal fraction concentration is not diagnostic per se, it is related to diagnosis. A diagnosis of the illness would require additional testing. Therefore, court determined that section 3A of the Act was invoked since the claimed invention was inherently incapable of recognizing a disease. Now, let us see patentability of diagnostic techniques in other jurisdictions. The flexibility granted to member states, which we have already seen under the TRIPS agreement regarding incorporation of diagnostic procedures into non-patentable subject matter, has resulted in varying global patterns. Countries with divergent economic, social and political systems hold varying stance on the matters of public health. So, after the TRIPS, it is the flexibility given to the countries to decide whether diagnostic procedures would fall as a non-patentable subject matter or is patentable to some extent. So, many of the developing countries and underdeveloped countries has used this flexibility and kept diagnostic procedures as an excluded subject matter from patentability. So, now let us see a comparative perspective of different jurisdictions, starting with United States. In US, a patent can be obtained for any new and useful process, machine, manufacture or composition of matter as given in 35 United States Code section 101 of the Patent Act. However, claims pertaining to law of nature, natural phenomena and abstract ideas are not allowed by judicial exceptions. So, as such, even any useful process, machine, manufacture or composition of matter becomes patentable under the US law. However, there is an exclusion with regard to laws of nature, natural phenomena or abstract ideas. So, if whatever is claimed is on the basis of laws of nature, then it may become unpatentable or ineligible for patent in the United States. But at the same time, if it is something new and a useful process, even if it is for a diagnostic purpose, then it becomes patentable under the US law. The patent eligibility of diagnostic methods has received significant court scrutiny in the United States. The Supreme Court, in the well-known decision of Mayo Collaborative Services versus Prometheus Laboratories, held that it is not possible to get a patent for natural laws and their practical implementation. In order to be eligible for a patent, a claimed invention must possess additional characteristics that introduce novel aspects to the natural event. So, in Mayo versus Prometheus, which is a well-known decision, the claimed invention was actually based on natural laws, even though it is for a diagnostic purpose, and the invention in effect claimed the practical implementation of natural law. So, because of this, the court held that it is not patentable. So, in order to be eligible for patent, the claimed invention should possess some additional characteristics that will introduce novel aspects to a natural event. Now, let us see another jurisdiction, Canada. Although obtaining a patent for a diagnostic method in US is difficult due to the well-known Mayo decision, other countries, especially Canada, have shown their readiness to acknowledge the patentability of diagnostic techniques. In Canada, Patent Appeal Board has recently affirmed the diagnostic method might be eligible for patent if the method incorporates physical mechanisms for measurement rather than being solely based on a mental process. If it is something more than a mental process and incorporate a physical mechanism, then it could be patentable in some jurisdictions like Canada. Now, let us see European Union. According to Article 53C of the European Patent Convention, the European Patent Office specifically prohibits patenting methods for treating human or animal body through surgery or therapy, as well as diagnostic methods performed on human body or animal body. However, this restriction is not applicable to products such as substances or compositions that are intended for use in these methods. So, as such, under the European Patent Convention, patenting of methods for treating human or animal body, whether it is through surgery, therapy, as well as diagnostic methods, are non-patentable. In Australia, diagnostic procedures are not prohibited from patenting under the patent law. Patents are granted for inventions that are product of deliberate human endeavor and do not arise naturally. So, those who are products of deliberate human endeavor, it becomes patentable in Australia. The patentability of diagnostic procedures was affirmed by the Federal Court of Australia in case of Ariosa Diagnostics versus Sequenom in 2021. The subject of examination was a technique for non-invasive prenatal blood testing. Given that the testing procedure was a deliberate process for identification rather than a naturally occurring phenomenon, the court determined that the innovation in question had economic value and practical usefulness, thereby making it eligible for patent. So, the testing procedure, as it is a deliberate process for identification and it is not just a natural phenomenon, the court felt that the innovation in question also has economic value and practical usefulness, and because of these reasons it is eligible for patent. To conclude, diagnostic methods play a key role in both patient care and medical research. Encouraging innovations in this highly advanced domain would be advantageous for the well-being of general population. However, it is important to ensure that encouraging innovations does not jeopardize public health. An equilibrium must be achieved. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.